H. Jackson is a legendary figure in our country, Pennsylvanian by birth, and most of his activities were in Jamestown, and came to Washington at the request of President Roosevelt in some very troublesome days in our nation's history. He worked at the Internal Revenue Service as general counsel, and then was an assistant attorney general and became attorney general, and a very, very distinguished Supreme Court justice. He has written some of the most often quoted opinions, had a really sense for the core problem, could really move, so to speak, to the jugular in a very graphic, articulate, and memorable way. He wrote one famous line that the Supreme Court is not final because it's infallible. The Supreme Court is infallible because it's final, which is an honest way of putting it. The Supreme Court captions their writings as opinion of the court. Well, I think that's appropriate. It is their opinions, and they do have the last word. He also coined a very famous expression when he wrote that the Constitution is not a suicide pact, that there are some practical considerations as to what constitutional law means. And there is an ongoing debate as to the role of the Supreme Court. We all agree that the Supreme Court ought not to make the law, they ought to interpret the law. The opinion that I think Justice Jackson is best known for was a concurring opinion in a case called Youngstown Steel, where President Truman seized the steel mills. And one of the really vital parts about our structure in government is separation of powers, that no branch has too much power. And the Supreme Court of the United States decided in 1803 in Marbury versus Madison that the Supreme Court had the final word. Constitution doesn't say that. But when the Supreme Court decided it, they've made it stick for the life of our country, and somebody has to have the final word, and institutionally I think that has worked well for the country. And the Supreme Court has been independent, and notwithstanding Justice Jackson's close relationship with President Roosevelt, and President Roosevelt's appointing him when the famous Korematsu case came up about the internment of Japanese citizens during World War II, Justice Jackson dissented, said that that was an inappropriate and unfair infringement on the constitutional rights of the Japanese citizens. And that dissent and his reasoning in that case have come to be regarded as the appropriate decision. And in the steel seizure case, he wrote a concurring opinion which has been often cited in recent times when the conflict has arisen between the Congress and the President. But Justice Jackson wrote in the concurring opinion in the steel case that the governmental power is at its strongest when the President and the Congress join together. And presidential authority is at a medium point when the Congress has not said one way or another. And presidential authority is at its lowest point where the Congress has said the contrary, that you can't do something like warrantless wiretaps, and the President disagrees and steps in, notwithstanding a congressional statutory provision to the contrary. So in the hearings which we had 3 years ago for Chief Justice Roberts and Justice Alito, Justice Jackson was quoted very frequently in those proceedings, and they were really sort of historic proceedings.